Hey everybody, hope everybody's having a real good week. We're going to do our lecture here on employment law, and we're going to talk about different types of discrimination, if you will, and going through this lecture. Got a glare. You see, I think you can probably see it from next. So I try to sit over. I try to sit over this way right here, so you won't have so much of glare coming in on you there. All right, types of discrimination. Okay, we're going to talk about this. You got your outline in front of you here. All right, and when we talk about discrimination, we talk about, if you look at your very bottom there, we're talking about discrimination based on race or color, discrimination based on religion, discrimination based on national origin, discrimination based on gender. We're going to talk about age discrimination and Americans with Disabilities Act. All right, so when we talk about the different types of discrimination, like disparate treatment, and disparate impact, we're just going to go through it in just a minute here. We're talking about those type of protected classes. Okay, so let's look at types of discrimination now. By the way, I've been on both sides of this. I have defended and been sued on both. So I've been on both sides of this many times in federal court, in litigation, if you like, if you will. All right, so disparate treatment, number one, okay? Disparate treatment is discrimination occurs by design because the employer intentionally discriminates, such as carries two different help wanted columns, one for men, one for women. That's common sense, isn't it? All right, we don't have any problem with that. Disparate treatment is, it's there. Women not apply, men need not apply. Just whatever religion, certain religions must apply, can only apply. That's obvious right there, okay? So what do you have to prove now if you've been discriminated against because of disparate treatment? What do you have to prove? Now we're going into court here, okay? So let's look at it. A up here. Procedures you go through. You're in court now. You're going to sue because you've been subject to disparate treatment. Okay, disparate treatment those are not hard cases to prove, by the way. But what do you have to go? What steps do you have to go through in federal court or state court to win the case? Okay, the procedure. Plaintiff. Now, who's the plaintiff? Plaintiff is the person discriminated against. That's the person filing the lawsuit. Plaintiff employee must establish a prima facie case of discrimination involving hiring, promotion, or salary increase. Any of those, okay? All right, now what's a prima facie case? I think we talked about prima facie case in civil procedure, or you have it also in criminal cases, okay? You have to prove a prima facie case. That is enough evidence to where a judge will let it go to a jury. If you don't have enough, remember we talk about criminal law, where if you arrest somebody and you don't have a prima facie case, and the judge don't let it go to the jury, then it's double jeopardy. You can't bring it again ever. Okay, so you want to have enough evidence to where you can get the case to the jury. You got to get it past the judge to the jury, because if you don't have a prima facie case, if you don't have a strong enough case to get it to where the judge says no, you haven't shown enough evidence to even show a prima facie case, not even probably, it probably happened, okay? So I'm not letting you go to the jury with it and throws it out, and you can appeal that, but that's what a prima facie case is. And if in a criminal case, it's like you know who killed the person, but you don't have enough evidence to prove it, and you go to court, the state puts the case on, and the defendant makes a motion for judgment acquittal and states grounds, therefore the state didn't prove a prima facie case of murder. If the judge says there's not enough evidence, grants your motion for judgment acquittal, there wasn't a prima facie case proved, boom, case gone. Same way in discrimination cases or any other civil case. Okay, you got to prove a prima facie case. All right, so here we go. So the plaintiff must establish a prima facie case of discrimination involving hiring, promotion, or salary increase. B, what do you have to do to prove a prima facie case? The plaintiff employee, when suing the case, must show that he's a member of a protected class. We went through that. We started lecture with a protected class, didn't we? Okay. Number two, he applied for and was qualified for that job. All right. 3, the application was rejected. And 4, the employer continued to seek applicants or that a person in an unprotected class was hired. Okay, that's what you got to prove there. It's not hard to prove. If you're going with disparate treatment, that's not really hard to prove. Okay, if a prima facie case is shown, the defendant, employer, defendants when plaintiff suing, defendants when defendant, court must rebut by having a valid legal reason to hire the person that was eventually hired. Now, if you're claiming disparate treatment, that's going to be hard for the employer. I'm going to promise you this, because I've done it so many. It's going to be hard if I'm suing somebody because my client's been discriminated because of disparate treatment. It's going to be hard for the employer to come in and rebut my prima facie case. I said I had a valid reason just to hire, somebody of a certain religion or whatever, a certain gender or whatever. Had a valid, and that could happen, but it's hard. It's harder on that. Okay. Now let's look at the second type of discrimination. Okay, disparate impact. Okay, what is that? That's where the employment practices appear neutral on the surface, but without any intent to do so, the practice adversely affects a protected class. So you did not mean to discriminate a person that was over 40 years old, which would be age discrimination, but because of the way you advertise or the way you do your promotions or your salary increases, it just does that, okay? You may say that anybody applying for this job must be 6'2". Okay, well that's going to discriminate against a lot of people. All right, and so you say, well, I didn't mean to discriminate against anybody. We just need people 6 foot. Well, okay, well then let's say why you got to have people 6'2". All right, so again, disparate impact is where you don't mean to discriminate, but because of your policies or because of the way you do things, or your advertising, whatever it is you're doing, or your salary increases, it could be discriminatory. Okay, and you got to be real careful about this stuff, folks, because you cannot say, you can't have you can have the best intent in the world, but you still could discriminate against somebody if you have discriminated because of your practices, culture of the business, whatever. Okay. All right. Now let's look at this. Okay. So if you have an disparate impact, okay, what do you have to prove? Okay. Procedure same as 1 through 4 above. Okay. So if you're suing somebody for disparate impact, you have to go up here. Plaintiff must establish a prima facie case of discrimination involving hiring, promotion, or salary increase. To prove a prima facie case, plaintiff must prove, remember, that you are, number 1, you're a member of a protected class. 2, you applied for and was qualified for the job. 3, the application was rejected. 4, the employer continued to seek applicants or that a person in an unprotected class was hired. Okay? So again, the employer could have the best intent, but it always turns out to where the person that gets the job is from an unprotected class. And you can go in the cases where I've sued, and you go in and you say, the employer says, you're taking a deposition, we talk about depositions, and the employer says, well, we didn't mean anything by this. Our policies are in our manual here, we didn't mean to be discriminated. And then you go through the deposition, you go through all the records, and you go through everything. So you've made, given 200 promotions here, and nobody in this protected class. You're always discriminating against the protected class here. Okay, one of the protected classes. So what is you may not mean to be discriminating, but what is you prove? Maybe you had 1 out of 200. what's your problem here? You know, and the person said, well, I want you to know I'm just not that type of, well, but you are. Your policies are discriminatory. You see where I'm coming here? I mean, you can be taking a deposition. I've done so many times, and the employer says, "Whoa, I wasn't doing anything. I didn't mean. I've got a good heart. I wouldn't. But look what you. Let me show you your records here. Have you ever looked at your records here, and gone through this thing and say how many people got promotions or raises, and how many of these people, you know, in this protected class did not get the promotion, did not get the raise, did not get the job." And it's, you know, I mean, what they're doing in one case is like almost 400 times. And they, you know, it's like, whoa, wait, but person, oh no, no, I'm not that type. Well, you may not be that type of person, but look at your records. Have you looked at them? Okay? No, sir, I hadn't looked at them. Well, let me show them to you. Would you say that they look, take your time, have a recess, you can look at them. You read your lawyer, you'll look at it. You know, and then we come back from the German or recess or whatever. You go back in deposition. Did you look at them? Yes, I did. Does that sound to you? Does it look to you like your company's discriminating here? And the person says, yeah, it does. But I got a good heart. I understand that. I know that. But you're violating the law with your policies here. You're discriminating. Okay, that's how it works with the disparate impact. Disparate treatment is there. I mean, just boom. But disparate impact, you know, you go into it and you get the records and you show it that way. So the procedure, okay, once the plaintiff has established a prima facie case, the defendant has the burden of proving a legitimate, non-discriminatory reason for the applicant not being hired. If the defendant rebuts the prima facie case, the plaintiff must next convince the judge or jury that the reason is a pretext to cover up discriminatory employment practices. That's the way you do with records. Okay, that's when you convince the judge or the jury that the reason is a pretext to cover up discriminatory employment practices, and that's how you do it with your records. These cases are when you go in for the disparate impact case and you're suing somebody, suing a company. You better be ready. I mean, you better be ready to take a lot of depositions and go through a lot of documents, okay? Because, like I've told you, people just don't admit it, okay? So when you pull the records out and you show the records, and it's, okay, yeah, okay, looks bad. You know, I'm not centered on this thing. I can get over here, but if I do, you see that light's coming on me. So that's the reason I'm kind of sitting over here, so we won't have that glare there. All right, so there we go with the types of discrimination. All right, now let's look at our equal employment opportunity procedures, EEOC procedures. Okay. Well, first of all, let's see if we can get a test question out here real quick here. Let's see here. Okay, let's see here. Get notes here. Here, I think 42 here. Let's see here. All right, here's your test question, one of your test questions. Sometimes employment practices may appear to be neutral on the surface, but nevertheless adversely affects a protected class. This is the nature of A, disparate treatment. Okay, remember, okay, let's look at this, number 42 here. Okay, or B, disparate impact. If I don't have to go class B on that one, do I? Sometimes employment practice may appear to be neutral on the surface, but nevertheless adversely affect a protected class. This is the nature of B, disparate impact. Next number, when a person is told that he will be discriminated against him because of his gender, he feels the effects of what? A is disparate treatment, and I have to go further than that, do I? That's that, okay? Title VII covers employees with a minimum of, we'll get that in just a minute, it'll be 15 workers. We'll get that in just a minute. So that's going to be just 3 or 4 more questions on that, and that's going to have to do with these time limits we're about to go through here. Okay, so again, y'all had enough of my test to know now exactly how this how this thing rolls, okay? So let's go through, okay, now we're going to go through our EEOC, our Equal Employment Opportunity Procedures, okay? These times are very important here. Keep this in mind, okay? All right, charge must be filed within 180 days after discriminatory action. What if you wait 181 days? Then you're out, okay? So you've got 180 days to file the claim, okay? EEOC must notify the employer within 10 days after the filing, within 10 days after the employee files the notice, okay, files the claim, all right, the charge. Then the employer has 10 days, the EEOC has 10 days to notify the employer. The employer, this is very important, cannot retaliate. Now, if a person files an EEOC complaint and the employer fires or decreases salary, anything, that's retaliation. And if it's a sex harassment claim, whatever we're talking about in just a minute, whatever the claim is, and you retaliate, you take that person, you move them into it, you can move them to a different office. They got one office and you move them to another office, that could be retaliation. Okay? So again, you cannot, that's very, very important right there. B, the EEOC investigates. All right? Then the next one is if the EEOC finds a reasonable cause that federal laws have been violated, it attempts to resolve by informal means. Now what you do is the lawyers go in with the clients and you go to the Equal Employment Opportunity building, office, and they're building EEOC employee there. It's very good. By the way, they do great. They do great in these. It's kind of like a mediation. Remember we talked about mediation? It is kind of like that, and they do a great work. Okay, they try to resolve it. They try to resolve the case. It's better to resolve a case instead of going, if you resolve it, you know what happens. If you don't, then you go in front of a jury. You never know what's going to happen. I've told you that I do most of my work in the courtroom. Okay, but I can tell you that there's some very good employees at EEOC that the Equal Employment Opportunity Commission that really attempt to try to resolve these issues. So that's number D. If the informal means, if let's see, the EEOC finds a reasonable cause, federal law has been violated, it attempts to resolve the informal means. Now, D, if informal means fails, EEOC may bring an action within 30 days after the charge is filed. So EEOC can file the lawsuit, can file the claim. Okay? Now this is important, E. If EEOC does not find reasonable cause, it notifies the plaintiff of the right to pursue the matter in court. The plaintiff has 90 days to file the suit. So if EEOC finds reasonable cause, they'll file the lawsuit. If they don't find reasonable cause, they notify the plaintiff of a right to sue. Then the plaintiff, the employer, has to file that lawsuit within 90 days, not 91 days. Remember we talked about how important is statute of limitations. I mean, you don't have. I mean, if it says a certain amount of time, 2 years, it's 2 years. Here's 90 days, 90 days. Now, let me tell you, you people are going to be lawyers. A lot of times you're going to get calls from people on the 89th day. I promise you. It's like you go into a criminal case, you're going to get a call on Friday and people say, well, can you represent me? Well, what are you charged with? Trafficking and fentanyl. All right. When did you get arrested? 2 years ago. I got court Monday. Well, you got your jury trial set for Monday. Yeah, I got my jury trial set for Monday morning. Okay. Well, no, I hadn't got time. I can file a motion. If I file a motion for continuance, then I'm in the case. If the judge denies it, I got to try the case. Monday morning, I've got 2 days to prepare. You can't do that. It's impossible. Okay, so you get these calls. You people are going to be lawyers. Pay attention to this. You're going to get. They're going to call you 88th, 89th day. Hey, I got this right to sue letter, and here's what happened, and will you represent me? Well, you've got 1 day to decide whether or not you're going to file a lawsuit. Okay, because look here, you remember what it says down there? The plaintiff has 90 days to file a lawsuit. You're going to get called on the 88th, 89th. I promise you. It happens it's like somebody has an accident, they got 2-year statute of limitations, and they come on to you and it's a wrongful death action, whatever, something really, or products liability action, some kind of real tough action, and they come to you the last day before the statute. I mean, you had 2 years. I mean, I promise you, the insurance company's been working on it. They've ready. And now you got, a day to decide, do I file this multi-million-dollar lawsuit and hire experts and do other stuff and I don't have any discovery or anything right now. So, if you get that right to sue, if you don't have the lawyer, if you just was doing this on your own, go to the lawyer right when you get the right to sue and get you a lawyer and let the lawyer look at the case and decide whether or not they've got a good enough case to file the lawsuit for you, because the EEOC has found that they didn't see that you had a reasonable cause to file the lawsuit. That don't mean that you don't. That just means go get a lawyer and let them take a look at it, okay? All right. So again, let's go to the C there. Again, look up at C. If EEOC finds a reasonable cause, that federal law, not that it has absolutely found, but just reasonable, okay? Hear that term? You could be looking at it and say, now, can't you do better than that? I mean, we're this far in the course now. We're right at the end of this course, and you're still using this term reasonable, like reasonable doubt, and now we're in the civil rights actions, and you're saying, you're looking down here and say that if EEOC finds a reasonable cause, what is that, lawyer? Can't you do better? Can't you put in some kind of formula or something there? Well, I can take you right back up here. Member of protected class. 2, applied and was qualified for the job. 3, application rejected. 4, employer continued to seek what, up there, right above. Okay, what is reasonable? Okay, like I told you a while ago, if a person says they're not discriminating, but they've done 200 people, give 200 raises, give 200 promotions to people, and they're always discriminating. But yeah, that's reasonable cause to show something. Okay, so this term, if they find a reasonable cause that a federal law has been violated, attempts to resolve it by informed means. If informed means fails, EEOC may bring the lawsuit, may bring an action 30 days after the charge is filed. Keep doing this because I see so many people, so many young lawyers a lot of time, and they miss these dates, miss these times. Man, you need this. This is you've got to go by these, okay? If the EEOC does not find reasonable cause, it notifies the plaintiff of the right to pursue the action in court, and the lawsuit has to be filed in 90 days. What they're saying here is if EEOC does not find reasonable cause, that does not mean you don't have a lawsuit. That means if you don't have a lawyer, go see a civil rights lawyer, go see somebody that files these actions, works in these type of cases, and go through it with them. They may say you've got a lawsuit, and then they file a lawsuit. They got 90 days to do that. Okay? So, and again, by the way, I can't stress enough that how when you go to EEOC and you go in and you deal in these matters and you work with these caseworkers, they usually are very helpful work, but they really are helpful. They really try to resolve these matters. They really they try to do the right thing in these matters. So and again, I've been doing it a long time, and I've gone through the years, and you got you got different people in that when I first started, and it just seemed like they're just really sincere, good people that are trying to do the right thing. The EEOC workers are. Okay, categories of discrimination. We've already talked about that. All right, Title VII applies to employees with 15 or more employees. All right, now, what if you got 10 employees? Does Title VII apply? No, it don't. What if you got 14 employees and then you got one that comes in every now and then? Does that count 15? Well, that's a good question, and that gets litigated, but most time. One side saying they don't have 15, well, they had 14 full-time, one person came in every now and then. Generally speaking, they would say that wouldn't be 15, but you can make that argument. You can take the depositions and say, wait a minute, these people, they were doing this just to keep it down. They were really just doing this, paying this person this way just show they didn't have 15, so Title VII wouldn't apply to them, but the person was in fact a full-time employee. Don't take it face value if somebody says they file a motion to dismiss and say, well, we just had 12 employees, we didn't have 15. Dismiss the case. Well, you want to take some depositions and you want to go into this person's records again and stuff and show, well, we got, we had 12, and that's all we had. Well, you get in them records, you find, wait a minute here. You got, 7 more people working for this company that you're paying this way, just so you won't have to show you got 15 people. And you do have 15 people, therefore Title VII does apply to you. So when you're the lawyer and you get you've sued and the person comes out and says, Title VII don't apply because I don't have 15 employees, don't take that at face value. You check that out. Remember what I've talked, a number of my lectures, I hope I've stressed to you, well, just say, okay, that's okay, I'm sorry. No, check it out, okay? Because you may find out the person got 30 employees, but they saying they got 12, or 14, I've got 14, I barely, well, not really. Okay, so check it out, 15 employees. Again, what the rules say, and people go, they say, okay, I'm going to get out of it because of this, but that's not really how they've been acting, okay? So we've talked about the protected class there. Let's go down to number 4, discrimination based on gender. And let's look at gender discrimination or using sexual harassment. And I've got 2 pages notes here, so I'm going to turn those. And you got 2 types of sexual harassment. You got quid pro quo and hostile work environment. Now, quid pro quo is not hard, easy to show. All right. Now, by the way, generally speaking, in my time in practicing law, you have people that have been recorded making these statements, quid pro quo statements. It's not just one on he said, she said, or he said, or she said, she said. It's not that way. It's usually you have some recording or you have somebody in the room, whatever. Quid pro quo, and I won't embarrass anybody here, but quid pro quo, you know what that is. You do this for me, I'll do this for you. That's quid pro quo, okay? That's, if you got that recorded or you got a witness to that, then you got sex harassment, okay? Now, by the way, you know what I didn't have when we started practicing law in 1976 and I started practicing law? I didn't have the internet. And we didn't have emails and communications phone to phone and stuff like that. Okay, we didn't have that stuff. We got it now. Okay, now why some people? You go tell me. I'm talking about people, educated, smart people who've been successful in their businesses, made a lot of money. Why are they getting on their phone and sending these text messages that would mount to quid pro quo? You tell me why they do that. I don't know, but I can tell you they do. Okay? I can't figure it. I'm looking at you right now. I'm looking at 150 students right now. And I'm looking at myself right now. I'm looking at, but I'm talking to 150 people. All right? Or however how many people listen to this lecture. You'd think they'd have better sense of it, but they don't. I'm just telling you. And I didn't have that back in, it was a long time. From 1976, before I started having, text messages and emails and stuff, my goodness, it's a lot easier to prove a case now. You don't have to have a recording, and this person put it in their text message, okay? So quid pro quo will not embarrass you, but if you could read some of the things I've read and heard, recorded, you probably wouldn't believe it, okay? Because everybody watching most like you young people, you've had these, I didn't have that when I was coming up. You've had it. You've got more information in your hand than I had in my whole life up until 2000 something. I mean, we had to go to libraries. I mean, I got hundreds and hundreds of books out there. We had to do research, looking through books and digests and stuff like that. Hours and hours and hours of doing legal research. Now you can pick up this computer I've got here. You type something in here and pulls up all your cases and research and all kind of stuff. We didn't have that when I first started, but it's a lot easier proving cases now. I can tell you that. I'm like, my Lord, look at what this person. One of the lawyers come in and said, "Look at this." Man, I thought that lady was a lot smarter than that. She should, but here we go. And like I said, when you defend them, you're stuck with that. I mean, if you're on the other side, you're glad to see it, but you may be on the other side, okay? You have to deal with it. So that's quid pro quo. But what is hostile? And that's hostile work environment. Second way. Now let me tell you this. It's kind of good to remember. It's not in your book. A lot of stuff not in your book. But anyway, this is not in your book. What's funny at the copy machine, you just call it the water fountain or the water cooler and all that stuff. But the copy machine or where you talk around the computer, the break room, what's funny in there? It's not funny in federal court. What you said, you're the boss or you're the foreman, you're the person in charge, and you're always making these little sexual remarks, you're making these little remarks. You do it in the break room and everybody laughs, and you get sued for sexual harassment, hostile work environment. Well, it was funny. Everybody laughed. It's not funny. You know what I tell them, guys, men and women, when I'm representing them? Don't laugh in the courtroom, because you in that federal courtroom, you got a federal judge sitting up there, you got a lawyer sitting on the other side that's about to rip you up. I won't say rip you up. I won't embarrass anybody. But I tell my clients that. They're not going to laugh. In that jury box, they're not going to be laughing. Because that jury in the jury box got children and they've got grandchildren working in a place, and they don't want their children and grandchildren having to hear this kind of stuff, especially if they work for the person. Okay. So what's funny, and they send the text, they send the emails, dirty stuff over that to some, and the person can laugh about it. Well, that person is working for you. That person is your employee. That person's trying to keep their job. They got bills to pay. They got children to take care of. And they laughed. That don't mean they thought it was funny. That means they very easily mean they're in a hostile work environment. Okay? And once they can prove that you said that, and that's something that you acted, the way you acted, and you were coming on to them with these dirty jokes or dirty whatever you're saying, then that could be a hostile work environment. Okay. Now let's look at this right. You see this? Okay. To prove sex harassment, the employee must show, number one, that the conduct was of a sexual nature. That's not hard to prove, especially if it's in an email or a text. Or you can have it. Now you got videos, and now you got video of people touching and doing things. Okay. Two, that it was unwelcome. All right. Now, again, laughing at a dirty joke, that don't mean it's welcome. Okay, that don't mean, oh, I'm enjoying this. No, the boss saying it to the employee, and the employee laughing, that don't mean they're welcoming it. Okay? It could even go further than that, and it could even be more egregious than something actually happens, and it could still be not, it could still be unwelcome. And be, well, he consented or she consented. No, you're the boss. You're the boss. Okay. Don't work that way, because you're talking about hostile work environment here, and it's not necessarily welcome. But you're the boss. You're in charge. They're trying to keep their job. Okay, you got juries in that jurors in that box listening to this case. You don't know who's on that jury. The lawyers don't know that jury. I can't tell you. I've told you this before. I can't tell you if you're going to win your case or not. But juries don't like that kind of activity from a boss. Okay, they just don't. Okay, I'm just telling you. Generally, you don't have 12 CEOs on that jury. Don't work that way. Okay? I'm guaranteeing if I would not, if I'm representing somebody, I'm not going to have, doing a plaintiff, I'm not going to have that. Number 3, that it was severe or pervasive enough in nature to alter the conditions of the employment. Now, what is that? Okay, that it was severe or pervasive enough in nature to alter the conditions of employment. Okay, now that's where you go in to when we talk about our philosophy about virtue and all that. And also, it's where you use your common sense, because you could say to me, okay, wait a minute. Now, again, I need to know what severe and pervasive enough is to alter the conditions of employment. Do better than that, lawyer. Well, I can't. There it is. There it is. And that if the jury believes that, if they believe that the way the employee was treated, okay, was severe and pervasive enough in nature to alter the conditions of employment, then you're going to lose your case if you're the employer. That's up to a jury to decide, isn't it? And I always tell juries, use your common sense. All right? I always tell the story. There was a young king. He lived many, many years ago. And this young king had the opportunity to have anything that he wanted. He could have all the money. He was given this opportunity to have anything he wanted. He could give all the money in the world. He could have asked for it, it would have been given to him. He could have asked for all the power in the world, and it would have been given to him. He could have asked for all the land in the entire world, and it would have been given to him. But this young king said this, give this thine servant an understanding heart, that he may be able to discern good and evil. For who can judge this thine so great a people? The young king was Solomon, and Solomon asked for wisdom. Wisdom, I think, is common sense. We all have it. Remember when we talked about ethics a long time ago. Momac told me, grandmama told me, a long time, a little boy. And Momac told me, he says, you know if it's right, you feel it in your stomach, Mark. I've probably done something wrong. Momac was telling me that point. You know if it's right or wrong. I always tell juries that. Use your common sense, and that'll give you the answer to this right here. That it was severe or pervasive enough in nature to alter the conditions of the employment. Use your common sense. I've showed you the case. You've heard the evidence. This young girl, working in this place, and what she had to put up with. The issue is, what are you going to do about it? You're going to use your common sense, ain't with one just verdict and come back with. I humbly and respectfully maintain. The only verdict you can do is come back in her favor. Anyway, but that's the way it kind of plays out. So I can't put the mathematics up there for you. I can tell you a bunch of poems, a lot more poems than I do tell a lot of poems and the like, because I think that can get people into they can feel it. The juries have to feel it. They have to, because they don't have formulas on the board. They don't have these. It's not easy. It's not like gravity or something like that. It's like love. We've talked about this. What is love? Love can be the most wonderful thing in the world. It can also get you killed. What is this thing? What is ethics? When I taught business ethics at UAH, I start off the class. What is this? It's like holding air, and you talk about moral relativism, virtue ethics, things we talked about in our first lecture, So we're back to this. We're back to what is right. You know how to act. You're the boss. And you know what's wrong. You read the manual, and the company can give you the manual all day long, but I've always said this, if they can give you the employment manual and all the employees, but if nobody goes by it, and then all the employees know you don't go by it, and then bosses know you don't go by it, then all this stuff happen, and you're going to have lawsuits on your hands. Okay. So anyway, we looked at this. You have a lot of cases like this, so pay attention to it. The hostile work environment is the one that's the sex harassment claims are mostly filed under that. There's not a lot of quid pro quos, but there is a lot of hostile work environment, sex harassment cases. Okay. All right, age discrimination. All I can say, all I'll say about that is that 40 years old. That's the age of 40 years old. Discrimination in hiring, firing, compensation, privileges, or other terms or conditions of employment is unlawful. The employer advertisements toward younger employees are illegal. They can advertise for somebody over 40 years old. Okay? So that's age discrimination, applies to employees that have 20 or more employees. Now, remember what we talked about, Title 7, 15. Age discrimination is 20 or more employees. But again, just because it's, we had 18, we didn't have the 20, don't take that on face value. You check that out, okay? All right, Affirmative American Disabilities Act, remember that's a protected class. All of this, you cannot discriminate against somebody if they have a disability. Everything I've gone through here, every bit of this stuff, if you do discriminate, if you run advertisements, if you do anything to discriminate somebody with a disability, that is a violation of that person's civil rights, okay? Now, we hadn't talked about, this is more of an employee lecture, and we'll talk about it, but let me tell you this before we go, and it just takes me out of the employment thing, but back into the law itself. If you're in jail, okay, if you're put in jail, you do not lose your civil rights. If you have a friend or relative in jail, that friend or relative does not lose their civil rights. I don't care if they're on death row. I don't care if they've been locked up over in the city jail for overnight because they got a DUI and they got to stay in there so many hours. They cannot violate your civil rights. The city, the state, the county cannot violate your civil rights. You have civil rights. You have a right not to be abused or put in a place where you will be abused. And I've represented so many people. I've told you before, I represented this young man that was beat to death, and he was put in. I think I've told you about the case. He was put in jail for unauthorized use of a vehicle. He didn't show up as probation officer in time. I think I've told you about this case. The officer put him in the Thunderdome, which was 9 people in there. 8 of them were in there waiting on capital murder charges. One had 9 sodomy charges on him. And they put this 19-year-old boy in there. The guard did, okay? And he stays up there. He has him up there a few days, and everything in the world happens to him. They finally kill him. And I'm not going to describe that to you, how they killed him, because I won't do it here, okay? But I sued because that's a violation of the civil rights, and I won the case, okay? In that particular case, just all the years they had a camera, and they said the jailer would go by and check and make sure everything was all right. But then on that particular night, for 18 years, that camera had worked, but it didn't work on that night. It's like on that bus where I had represented those young kids in Lee High School. 26 of those kids are represented injured, There were 4 killed, and I represented 2 of the families on the death case. And you know what? That camera didn't work on that bus that day. That bus went over the interstate over right here in Huntsville, killed them kids, them little children, students. Camera didn't work. Oh, I wondered why. Go figure. But you got civil rights. That's all I'm saying to you. And thank God you do. And you think, well, no, they are in prison. They ought not, but they do. Because if you get somebody, God forbid, you get arrested and you get put in jail, and you have to be held there for a certain amount of hours for some reason or other, and you get put in a bad situation, you know, and you might be put in that situation if there wasn't laws to protect you. And there are laws to protect you. It's a civil right. You have civil rights. They cannot violate those civil rights. Okay? They do, but then you can sue them. Okay? If the government violates your civil rights, if a big corporation, if somebody violates your civil rights, you got rights and you can sue them. Okay? In a lot of countries, you don't have those rights. You just don't. But you do in this country. You see, I kind of get fired up about people, because I represent people, and I've done it a long time. Represent people, good people that have bad things happen to them, because people think they can get by with it because they're poor, because they don't have something, and they get run over. And hope to God to keep people. I hope people listen to this, maybe here listen, taking this class, you're going to be a lawyer. Decides that's the way you want to spend your life. Representing people that get run over. I won't tell you how many letters I get from prisons. Just got through reading one. This young lady, women's penitentiary, not in Alabama, another state. What's happening to her is horrific. And I get letters every day like that. And I can't take all the cases, but I can sure contact lawyers in other states and see if they'll take a look at it. All right, affirmative action, that's the last thing on there. That's no longer the law. Our Supreme Court has ruled that is not the law anymore, not necessarily the law anymore. Remember this, the president appoints the Supreme Court, a member of the Supreme Court. If there's a vacancy, the president appoints the members of the Supreme Court, the Senate confirms them. Okay? That's how you get on the Supreme Court, and they're lifetime appointments. Those people who stand in that Supreme Court. Now, you can't be a judge in Alabama. You can't run for a judgeship on your 70th birthday. If you're 70, you can't run for a judgeship in Alabama. Now, if you're 69, you can run do it your term, but you can't run for election at 70 years old. But if you're on the United States Supreme Court, you can stay there till you're 90. You can stay there till you die. Till the day you die, you can stay there till you're 100. They can't make you step down. You're in there for a lifetime. All federal appointments, district judges, circuit judges, federal circuit judges, and United States Supreme Court justices. Okay, that's how long they're in for. Okay, and we've talked about this before. 5 judges say this is the law. That's the law. You see it. When we're talking about first lecture precedent, stare decisis. Once that precedent's there, but can it be changed? Yes. 5 judges on the Supreme Court, change the Supreme Court. Yeah, it can be changed, and you have a new precedent. Okay, and the people listening to this, we're going through changes now that I haven't gone through, since 1976. That I haven't gone through in my practice, in my law practice since 1976. We're having the Supreme Court ruling in ways that I haven't dealt with. I am now, because you know what? That's the law. Because why is it the law? Because 5 of those justices say it's the law, and they're in there for life. Okay, and when there's a next vacancy, what happens? Whoever's the president will appoint a person subject to Senate confirmation. And that'll be the next Supreme Court justice. Okay? Got some of them there right now, you're getting kind of old. But that's just the way it works. Okay? Now, with that, I got a little fired up in this lecture, I guess, I don't know. But I've seen a lot in my lifetime, and And sometimes it just don't, it don't, it kind of, poor people get to kind of small end of the stick or whatever, how you want to say it. I call it something else, but I won't say it here on this lecture to these fine students, good students that I got here. Thank you so much for listening to this lecture. I hope you learned a little something. I mean, you're going to get again, everybody listens. You know you're doing good. Everybody's doing good. You're going to do good. And I hope you have a wonderful week. Thank you so much.